Okay, the nature of image rights. One, you must know that image rights generate millions of dollars. It is commercial. It is revenue. It is making use of a sportsman's name and reputation. Now, image right also include other very interesting characteristics, such as his nickname, his reputations, his voice, right? Even his initials, his signature. Isn't that interesting? And caricature, if there is a cartoon versions of him. So we can see image rights come in interesting forms. And a commercial competitor like to exploit this for the purpose of getting more money. So at the end of the day, it's still revenue generating. Next, please, Diego. Now, image rights in modern marketing practice. We have team events and we have individual competitions. Right now, World Athletics are taking place in Oregon. And on day one, 2 athletes were suspended for doping, So team events will be soccer, cricket, hockey, field hockey, as in India, ice hockey, as we in Canada. So there will be also exploitations of image rights in publication, such as magazine, newspaper, and sometimes online media. And this day, online media plus social media do have exploitations of story and features in order to increase circulation. Now, mass media requires a high percentage of circulation for the purpose of getting advertising revenue, right? Now, then you have merchandise things like stickers, even playing cards. And of course, right now, computer games. Computer games are in abundant supply, and they exploit image rights of famous sports people. Then you have other things like advertising, marketing agency of many countries. They like to exploit image rights of famous personalities. For this lecture, I will only focus on sports person, right? But image rights include sports person and movie stars. But I will just focus on sports persons. Slide number 4. Now we talk about players' celebrity status, their reputation, they are famous. Now, players' agents are the one that have to secure endorsement and merchandising deals with commercial companies, sponsor. They have to leave to the agents. And the agents of famous players, quite a number of them are very well educated people with LLB and MBA. Now, superstar has 3 separate layers for commercial exploitation. Now, he can be exploited as an individual, as a person, or as a club player or a national player with separate commercial arrangement built around each of them. So one sports star can have his own individual image rights, or it can be associated with his club. Like a soccer player can be associated with a certain reputable soccer team or soccer club. Or a national player would then have separate commercial arrangement built around each of them. right? Like many cricket players in Pakistan and India to have image rights built even around their countries too. So we are talking about players' celebrity status. Next place. Now, substantial values of image rights. You can see here, David Beckham. I'm sure a lot of you know David Beckham. He was rather a very famous soccer star. Do you know he was paid 125 million when he moved to LA Galaxy, and then 80% given to him in respect of image rights, and 20% for playing. Can you just imagine? 80% given to him for exploitations of his image rights, and only a small fraction in actual playing. Now, the source was from the English newspaper Telegraph. Then we have another person, Tiger Woods. I'm sure for any of you here who is interested in golf, you will know Tiger Woods, right? Tiger Woods was considered a very famous sports star, golfer. And his brand, just his name, was valued at 55 million US dollar. Can you just imagine? Right? Just his name, his brand, Tiger Woods. And ahead of Roger Federer, the tennis player from Switzerland, valued at 26 million. And David Beckham, valued at 20 million. And this is from the financial magazine Forbes 2011. Now, we cannot let my assistant professor Diego Alonso off the hook because he's from Brazil. I'm sure Brazil, we will talk about image right, especially associated with Neymar, the superstar, or Pele. Am I right, Diego?
Yes, totally right, Professor. I got here an interesting case from Neymar. So Neymar in 2014, he sued the popular magazine Playboy, it's a male magazine, for over improper use of his image. So what happened is that the magazine published a cover with a beautiful model named Patricia Giordani, and the title was "The Brunettes That Seduce Neymar." And in the article inside the magazine, the model alleged that Neymar had an affair with her over the years 2013 and 2014. Well, for obvious reasons, Neymar sued the magazine over the improper use and spreading misinformation of him and his image, as he alleged never had any affair, basically never met the model. The magazine was found guilty actually quite fast in order to immediately remove any volume from the public, over a $10,000 fine a day, and indemnization to Neymar. Also related to image rights, Neymar has a famous case in 2017 when the Brazilian Revenue Agency charged him over tax evasion, alleging that he was receiving over $180 million in payment and using a company to pay the taxes. It occurs that the company belongs to his father, and he sold the image rights to that company. So that company would receive the money from image rights and pay over a fixed rate to Neymar. So everything here was regular. The Brazilian Supreme Court recognized Neymar's allegation and decided in his favor, saving him the payment of millions of dollars in taxes. So the company was paying at a rate of 15% taxes, and Neymar was paying over the regular 27.5%. But the difference here is who was receiving the money first and to who was paying the taxes. But anyway, in both cases, image rights related to Neymar, which is common.
Excellent. Excellent. Especially what you have said about namer, excellent. So you can see that making use of a commercial or a sports lawyer could end out in a reduction of tax payment. And that was recognized as what Diego said. So a commercial plus knowledge of sports law can make a world of difference. Slide number 6. Now we have to talk about legal status and protections of image rights. That will have to do usually with goods and services bearing the individual's name or image without authorization. In some cases, they do damage the value of the sporting personality licensing rights in his image. That is at the lowest level when goods and merchandising like t-shirts, that is quite at a lower level. Now, there is a case here, actually. Personality, merchandising, licensing rights, and much of the tourists that is found in a law journal that is something to do with legal status and protections of image rights. Now, with this, I would like to make an announcement. Most of my lectures, not all, most of my lectures have been actually recorded by my teaching assistant, Betty Ho, and have been posted on YouTube. You can go to YouTube, look under my name, look under sports law. You can get most, not all, of the lectures. Now, is Betty around? Do you agree with what Diego say about image rights in Brazil? Where is Betty? Oh.
I think Betty logged out. I think she's having issue. Oh no, apparently she's here. I just think she's not in her computer right now, or she's having trouble connecting.
Yeah, I think so. Because I would like her to comment simply because, one, she is a regular soccer player. Never mind. We go into slide number 7. We can ask Betty to comment later. Now, what is the positions under English law? Now, English law has regularly, consistently refused to embrace the principle that a person has a right to his name, her name, for the matter, like identifying characteristics such as voice and image. And that, surprisingly, came from Professor Cornish. Professor Cornish actually was my supervisor when I was studying law at LSE, London School of Economics, and that was what he has to say from his book on IP, patents, copyrights, trademarks, and allied rights. English law refused to recognize any embracement of a person's name, his voice, and image to identify such characteristics. And that came from a well-known, prominent professor of intellectual property. Slide number 8. Now, what do you do with unauthorizing use of identity in advertising? Now, people voluntarily enter professions which by their natural fame and reputation, they do invite publicity and they have to accept whether there is public approval or disapproval. And he should submit without complaint to their names and occupations and reputation being treated as public property. Whether you are a famous sportsperson or you are a famous politician, you have to accept the fact that your reputations, your names are just as good as public property. That is under English law, of course. That is very interesting. Now we come to slide number 10. Now, all of you know Elvis Presley. Elvis Presley, right? And there was interesting case arising from Elvis Presley. Of course, in this case here, it is an entertainment case, right? But we can use it in associations with a sports law case. He has to protect his copyright too. And that has to do with defamations, libel, or passing off. However, celebrity names and images have no monopoly under English law. That is very interesting. And this is based on the publications in the trademark world, which is a magazine. Now, the Elvis Presley Enterprise case, that was quite a useful case for reference. Slide number 10. Now, with image rights, we have to talk about defamation. Defamations in law can be slander, as in words, libel, as in written form. Now, unauthorized, illegal use of a person's name or image of a sports star can amount to defamations, but lower the moral standard or reputation, then come to defamation, as what Diego has mentioned in the case associated with Neymar. Now, a golfer succeeded in defamation when it was illegally, without his permissions, depicted in an advertisement with a packet of flies, chocolate sticking out of his pocket. Can you just imagine? Just using his picture and with a packet of chocolate sticks sticking out of his pocket, he succeeded in a case against the company arising out of defamation. So this has to do with image rights, and image rights associated with defamation cases. Slide number 11. When come to slide number 13, I will ask my teaching assistant Saket to give his case analysis. Okay, right now we are on slide number 11. Now, we have more defamation cases. Yeah.
Yes, Professor.
Yes. Now, again, sexuality. The case that my assistant professor Diego Oloso in Brazil mentioned with Neymar was associated with sexuality too. And in this case here, sportsman sued a magazine successfully is the word, for reporting that he was gay, when he always presented himself as a non-gay. So the action succeeded on this basis, and that publication defamed him by suggesting that he deceived the public about his sexuality. And this is reported in a sports law magazine, Sports Law Administration and Practice 2, Sexuality. In fact, quite a number of sports law cases, whether it was the world famous Neymar, as Diego has mentioned, that was again an association with sexuality, and also in other situations happening in Latin America, and also with very, very famous, world famous sports persons. Slide number 12. Trade Description Act. This is an English legislation. Now, it is possible to cover a case of a link with a celebrity, name or image to imply falsely that this person has endorsed the products of services, whether it's products or services. There is a typo mistake here, so we endorse the products or services. I quote the relevant section. Now, supplies or offer make to supply any goods to which a person under false trade descriptions, and this law is applicable. Like in the other case, which my teaching assistant Pia has mentioned, that was again has to do with trade description. Now we go on number 13. Now, advertising code that have to do with a lot of marketing agency. Now, people found guilty of cheating on TV program. Who wants to be a millionaire? That was an easy jet advertisement and carried the picture of the slogan. Need a cheap getaway? No fraud required. They complained unsuccessfully to the advertising regulator that the ads were consistent with court verdict. So that has to do with advertising infringement, which I'm not that familiar with. Actually, for defamations, based on my experience in the Supreme Court of BC on defamation cases, which I did for Chinese newspaper, the very important word is publication. Publication under defamation does not have to be printed publications. It can convey by way of words and innuendos and implied implications. So defamations is under two branches: slander, as in words; libel, as in printed form. Slide number 14, please. Now we come to copyrights. Image rights definitely have to be associated with trademarks, copyrights, and as well as patents too. Patents especially arising from social media and computer games. And yeah, I mentioned not very useful for control of image rights. Now, copyrights can be graphic representation, such as a cartoon. But then there is copyright in a photograph, and that belongs to the photographer. Now, no copyright whether there is face or in a name, but there may be copyrighted signature. No copyright in a face, that is quite obvious, or in a name, but strangely, there can be copyrighted signature. Now, slide number 15, or just to let you know, when come after slide number 16, slide number 16, my other teaching assistant, Yuga, will make another case review after slide number 16. Now we talk about trademarks. Image rights, as I mentioned earlier, have a lot to do with intellectual property cases. Now, this is an English legislation, Section 1.1 of the Trademarks Act. A trademark consists of words, including personal name. Now, this one have to do with soccer players. For some of you who are interested in soccer, you will know these two names. Now, Ryan Giggs is a Welsh player, I believe, and they are very famous footballers in UK. And they, too, even register their names as trademarks. Now, the other soccer player, Paul Gascoigne, Promotion Limited, actually he set up his own company. And his company registered the nickname of the footballer, his nickname, Giza, as a trademark. Now, you're a famous sports person, your nickname, your cartoons, your caricature can also be registered as trademarks. So you can see that sports law embraces image rights, and image rights give rise to intellectual property matters. Now we come to slide number 16. Now, club affiliations and the famous English football club. Now, can you sell souvenir, handbags, clothing that have the name Arsenal? Can you have that? In this case here, there was an infringement. As long as you can establish a material link in the course of a trade between the goods and services in issue and the trademark proprietor. Therefore, you are jeopardizing the guarantee of origin, right? In other words, the origins. That would be the key point. Now, with this, I will ask Yuga to analyze this very interesting case. Now, you can see here, there is the Arsenal case 2003. Okay, the Arsenal case, something to do with club affiliations and Arsenal Football Club. Now, I would like to invite any football fan from the class who is interested to help me to do a case review of Arsenal case 2003 RPC 9. Give your name to Yuga if you're interested to do this review for my final lecture or lecture 10. Slide number 17. Now, passing off, of course, is passing off in the law of tort. Now, how to eradicate passing off? One, to stop people from passing off their goods, especially clothing or services, as the sports personnel goods or services. It can come from a display of big advertisements in the car park, or it can be passing off like giving away freebies to participants in a soccer match or in a cricket match. It is definitely unauthorized use of the name or image of sports star to endorse the goods or services. In other words, to make use of their famous name without payment. As I mentioned earlier, image rights of famous sports star run into millions of dollars. However, English courts, being a little bit more conservative, were reluctant to protect sports superstar from unauthorized use of their names and images. And smart lawyers circumvented by going after the commercial companies arising from, as I mentioned earlier, defamations, slander. That has to do with passing off in the law of tort. Slide number 18. Now, we still talk about passing off, the tort of passing off. Why? Because there is goodwill. There's always goodwill in any particular trade or services. The defendant, usually a company which represents the goods and services supplied by the defendant, are connected to the claimant. In other words, they want to get the commercial value of image rights without payment. So there is likelihood of confusion, definitely, in the public of the material connection between the claimants and the defendant. And arising from this, there is damage to the claimant's goodwill or business. In an earlier lecture, we talked about the two famous movie stars, remember? And that had to do with the law of confidence. Slide number 19. Now we talk about the English positions after 20100. Now this case here was earlier analyzed by my teaching assistant Pierre, and I'd like you to take note of this important case. Irving versus TalkSport. TalkSports actually feature in quite a number of reported cases, Now, this case here, Irving was a prominent F1 Formula driver, and TalkSports runs a radio station and embarked on a special promotional campaign to cover World Championship. So what did he do? It sent out 1,000 media flyers of a flyer bearing the photograph of Irving. The original photo was cut and then pasted with a portable radio with the words "Talk Radio." That was a very intelligent way of getting commercial revenue out of image rights without payment. And that case was nicely discussed earlier by Pierre. Slide number 20. I will carry on with the same case, legal case in Irving versus TalkShops. Now, Irving did say the distribution of brochure bearing the cut and paste of him was falsely implied that he endorsed TalkSport, and it was actionable in the law of tort for passing off. But the court rightly held that it was not necessary to show that the claimants, the plaintiff and the defendant have a common field of activity. Therefore, the claimant, as a F1 superstar, had the exclusive rights to his reputations and goodwill. Now that, in a nutshell, the legal principle in Irving versus TalkSports. Now number 21. There are relevant legislations in England. There are relevant legislations in common law jurisdictions. One, the Human Rights Act of 1996 does provide the right to a person's privacy and development without outside interference. And then, famous superstars are protected under another act, the Data Protection Act of 1998, and that regulates the collections of data about individuals and may provide a remedy for misappropriation and use of image. Now with this, I would like to remind my law students from India that most of the lectures have been posted on YouTube. Most of them, not all of them. Slide number 22. Now we talk about image rights contracts. If you're a sports lawyer or a commercial lawyer, you have to do the drafting to protect the image rights of your clients. And your clients in this case will be sports celebrities, famous sports persons. Now that's what I mentioned earlier. A famous sports person and his agents may want to have their own endorsement activities. Like for example, the famous soccer star David Beckham has been associated with Gillette, with Pepsi. There is also club or team sponsorship collectively. For example, the famous soccer club Chelsea say that the players can wear their sportswear associated with their endorsed sponsor. And an endorsed sponsor can amount to, for example, Samsung, sportswear company called Adidas, or the motorcar, German motorcar, Audi. Now we move a little bit from the club level, then to the team level. From the team level, we move to the national level. Now, National Sport Association may want their national players to wear sportswear that will enhance sponsor value. So a famous sportsperson has to be contented with himself as an individual, number one. Number two, as part of his club. And number three, as part of the national sports. Now then we'll come to another layer. How about organizers of major events and competitions? They want to satisfy their sponsors too. And they want their sponsor to have exclusive rights of the images of the competitions organized by them. So we can see image rights contract come in different layers. As an individual, as a member of a club or team, or as part of a national or international sports association, and can also be part of the organizers. Now, right now, we have the cricket test game going on, right? Cricket test game going on. That will be under the organizers of the cricket test game. Now, finally, we have the last image, morality clauses. That is very important. Now, public image is everything. Public image has a lot to do with morality clauses. And earlier, my assistant, Professor Diego, mentioned about Neymar with association with something that touching on morality. Now, as I mentioned earlier, public image is very important to a sponsor. There must not be activities that bring the player's image into disrepute. That is in the minds, foremost in the minds of the public. And then if the player is innocent, he has to take immediate steps to sue for defamations. Sponsorships, what is sponsorships? It's all about revenue. It's all about money and creating commercial value. For example, we have the private life of Tiger Woods, or there was an incident of racial abuse of John Terry, a famous soccer player. You can see that he's wearing Samsung, right? Now, Tiger Woods became the first athlete to earn more than US 1 billion. US 1 billion. The first athlete in the world from sponsorships and commercial endorsement. Now, several sponsors, including the telecom company, AT&T, and later on broke up sponsorships arrangement, the fame, when his affairs come out in the press, in the newspaper. So image rights has a lot to do with morality and can be taken away if there is controversial issues arising from negative press reporting in the press, in the social media, in the mass media. Now, with this, I would say I would definitely like to ask any one of you, if you have any questions, we will have time for you to make comments